Clearly, inflation has had an effect on the amount required to deter when that is the basis for the award. An apology is relevant to the conduct of the defendant and therefore relevant to damages. The conduct of the trial is relevant. If the defendant persists in his support of his outrageous conduct at the trial, then that will sound in the damages. The identity of the accuser is important. An accusation made in a scandal sheet is one thing, an allegation made by the CBC is something else. One judge put it this way, the passage we quote in the paper, that's with the Vogel case, where the deputy minister in BC was slandered by the CBC or libeled by the CBC. Mr. Justice Essen said, the identity of the accuser is an important factor. The accusation might have been made by some nasty little tabloid scandal sheet and have done no harm. Strident scandal mongering is the stock in trade of certain publications, and they have little or no effect upon the opinions of anyone whose good opinion matters. Through their ugly accusations, it is sufficient response to say, regard the source. So it's important. That's why the CBC gets stuck with an award in the Vogel case of $125,000, of which $25,000 was the true punitive damages and the $100,000 was aggravated and compensatory. And on the facts of the case, it's perfectly clear that there was a substantial portion of that $100,000 that were aggravated. Otherwise, I think the punitive damage award would have been much larger. Clearly, I should mention provocation. We deal with the question of provocation in the paper and the question of whether it can reduce a punitive award, whether it can reduce a compensatory award, and it's an interesting and unsettled question that I'll leave you to read in the paper. Well, clearly, the rewards for bringing this kind of a lawsuit will ensure a speedy development in the law. Clearly, these awards are getting larger. They're affected by inflation. One of the cases we referred to talks about what the award ought to be based on other awards 15 years ago. Finally, I want to bring to your attention one other area that is worth mentioning and is a potential source of litigation in this area. And it deals with the Charter of Rights. Section 24 of the Charter of Rights provides a remedy, and a summary remedy, for breach of charter rights, and my view is it's one that you can enforce by simply issuing a writ in the Supreme Court of Ontario. There's no reason, in my view, that one can't bring an action in the Supreme Court for damages where charter rights have been violated. And there's also no reason, in my view, why significant damages should not flow if those charter rights are violated in a way that is flagrant, high-handed, outrageous, or the like. These damages may be compensatory if compensatory damages are suffered, but they are also like and may well be called punitive and aggravated damages. After all, what can be more serious than the high-handed, outrageous interference with someone's constitutional rights? And why should the remedy that is provided in Section 24, not among other things, be a damage remedy? And why, I say, should not the same factors be applied to the determination of these damages for constitutional torts when they occur that are applied in the aggravated punitive field that I've talked about? The purpose would be to punish the person that commits those constitutional torts and to deter others from doing so. Such an award was apparently made in a case in the federal court that was reported in yesterday's Globe and Mail. I don't have the reasons, but the CP story indicates that a prisoner who was incarcerated in one of Her Majesty's prisons, who was known as a rights activist, he was also a convicted murderer, was awarded $18,000 in damages by Mr. Justice DeCarey, I don't know if I'm pronouncing that right, in the federal court. because his constitutional rights were violated when he was moved to a maximum security institute from a medium security penitentiary. And the allegation was he apparently knew too much about the institute where he was and actively campaigned for the prisoner's rights, and that's why they moved him to another institution. Anyway, a judge in the federal court awarded him $18,000 apparently for punitive damages. So there is something to that, that potential cause of action. I'm convinced that the charter does have some teeth. Well, I started by saying that the next 10 years will see an explosion in this field. But I think that the foregoing analysis demonstrates that we're on the threshold. The law of damages in personal injuries developed as it did in response to the well-founded idea that injured plaintiffs had been shortchanged for years by the law, and the cases since the trilogy have indicated that. I suspect that judges and juries will use their power in the future to control outrageous conduct where it's proved in a similar way. You use it as some kind of a social instrument. And if the analysis of the law that I try to put for you today is correct, the legal basis is there to do it. Thank you.